Thank you for being here at SFSCon 2025. So, 15 minutes for you, and
Perfect.
Thank you. Stage is yours.
Thanks a lot. Good afternoon, everybody. Thank you for being here. We will deal today with a very interesting topic, and I will try to make it even more interesting given the moment of the day that is leading to the lunch. So I'm Federico Sartore. I'm a lawyer. I had the chance to deal with some of the most interesting AI case law in Italy, such as the OpenAI case with the Garante a couple of years ago, and some other interesting AI matters. And today we will speak about how the legal environment for AI regulation is not exactly what is what the public discourse is trying to say. So the fact that it's something that is hampering, it is lowering the space for innovation. On the other hand, we have a very complex environment that is mixing two main bodies, so the GDPR, the notorious, very well-known General Data Protection Regulation on the one hand, and the AI Act on the other. So we will see today how GDPR and the AI Act are two faces of the same strategy from like a broader geopolitical and strategical perspective of how EU wants to deal with technology and fundamental rights, fostering innovation, and so on. And in this very complex intertwined picture, we will see how free and open software may play an important role in trying to recreate some space for a responsible innovation, for a transparent innovation, trying to allow the people in the AI world to work with compliance obligation by in a new, free, and open manner. So as you can see here, GDPR is more rights and based regulation, while the AI Act is a new, more complex regulation that is more connected to AI as a product. This interconnection may lead to some discrepancy, to some conflicts. So together, they create what is conceived as the trustworthy AI environment. We'll see more in depth. So while the GDPR, as you know, is connected to data, so it's regulating a very non-material matter, the AI Act is more connected to real-world technology in the context of the EU single market. So the AI Act is very connected to a risk-based approach. So the idea of the EU regulators was to build a regulation that is giving stronger and more complex obligations connected to the risk level of the AI system. So there are the top of the complexity is represented by prohibited AI practices that are completely forbidden in the EU market. While if we deal with high-risk practices such as AI in the workplace, AI systems in the workplace, AI systems in education, we have a very complex and solid set of obligation connected to high risk, while if we lower the bar of risk, we have the so-called transparency risk, the level of obligation is definitely lower, and then we have the specific foundational models regulation that was inserted in the very last phases of the negotiation. So we have to deal with GDPR as a regulation that deals with very non-material and conceptual bodies of regulation. So we have to deal with transparency on how data are processed. We have to deal with lawfulness on how personal data are processed as well, and also with fundamental rights of data subject implementation. While the AI Act, on the other hand, as you can see, there are a lot of interaction that may create some struggles, but transparency is one of the core principles that keeps together GDPR and AI Act. one of the first scholars of privacy that founded the concept of privacy at the beginning of 20th century, William Brandeis, said that transparency, so the sunlight was the best disinfectant. So we think that open and free software can have this, in the AI world, can simplify transparency toward users, toward stakeholders, and so it should be emphasized, the adoption. Also because, as you can see here, so here, yeah, this is another slide connected to the fact that we have a different approach, but let's say we have to frame AI Act and GDPR in the same frame of fundamental rights of the EU, but they completely have a different approach. But as I was said, the scope is different, but the values to be preserved are the same. And so here we see that how can compliance be effective? In the GDPR, we have a compliance that is set to very specific obligations that should follow one after the other. So if you want to process personal data, you have to deal with a legal basis, and then you have to implement transparency obligations, then you have to record the processing activities into a record of processing activities or EROPA. For accountability purposes, you have to appoint a data protection officer and so on. While in the AI Act, the fact that risk is leading the obligation means that the risk assessment and impact assessment evaluation is more tech-oriented. So while ourselves as lawyers, we have easiest time with GDPR because everything is very theoretical, very conceptual. We can extract legal concepts from the technology. AI Act can be implemented only with a very strict cooperation between legal experts and technical experts. So, this is one of the fact that is creating some struggles in this implementation phase. That, as you may know, the AI Act is not a one-shot regulation. It was approved in 2024, but its full applicability is progressive. So now we'll see the full. It is probably in August 26, 2026, that the full AI Act will be in force, and a lot of criticism is rising. The fact that it's hampering innovation, and in this coexistence between legal and tech expert, I think that we'll see a space for, let's say, the success of the AI Act. And so, as you can see in this slide, the fact of having a full knowledge of the item, of the product that we are assessing is fundamental, because when we are in the high-risk area, in the high-risk zone, the number of obligations we have to deal are very technical, are connected to the fact of collecting all the documentation, transparency obligation, the fact of having human oversight mechanism, having a governance framework and recurring audits. So it is something that goes beyond what is merely illegal in the legal domain. So what can do free and open software here? In the AI Act, we'll see in the next slide that there is a kind of exemption for free and open software, open source software. But in any case, the fact of having transparent code and models, reproducible documentation, auditability of the code, the fact that we're having a community validation and peer review on the software is enhancing and having an easier time for those who have to do all these assessments. This is not something rhetorical. It's very interesting because there is a specific article of the regulation that says that the regulation does not apply to AI systems that are released under free and open source licenses unless they are in the high risk. So the first step is to say, okay, we are dealing with open source AI systems, so we have a lower bar of obligation, but we have to check whether we are in the high-risk zone or not. And the same things means it stands for GPAI models. So GPI models, general purpose AI models that are released under a free and open source license are exempt from the AI Act unless they pose a systemic risk. So systemic risk is still under the scope of application. In any case, you may know that the whole AI Act and other digital regulation are under scrutiny of a revision by the end of the year. So we'll see. There are some leaks. In the last 24 hours, there were some leaks on the new approach of EU that wishes to rebalance some pushes from internal government to have a simplified version of the regulation under, say, this pressure from government and some, let's say, lobbyists. So we are dealing also with evaluation of models. Evaluation of models is a very, very important thing that goes a bit beyond my, say, my domain. But we all know that safety of a model is not just something that could be connected to paperwork. So the fact of looking into a model is fundamental in the AI era, let's say in the AI world. Doing that with open source, obviously, and free software is easier. So there's a lot of space to test, train, verify, research that can be done on open source or on per se, or on open source to lead to better assessment, better methodologies for model evaluation also in the, say, non-open source area. So trying to, let's say, close this quick speech, we think that AI ethics, for instance, is a very non-legal area that is not pursued anymore a lot. It's more connected to research, academia, what was done by the EU in fostering AI ethics in this change of season can be enforced, cannot be enforced directly, so it's left for organization to be collected and implemented by themselves, while the legality can help to take some lessons from the AI ethics world to be inserted into the, let's say, strict legal regulation. And finally, this leads to a new role for to consolidate the role of EU as let's say, geopolitical area where there is a compromise between, but not a compromise per se, but a compromise, a virtuous compromise between innovation and fundamental rights. Yeah, we can skip it, but just to leave a last minute if you have some questions on some areas. In any case, I thank you for the attention of this speech, and thanks a lot.
Thank you, Federico Sartore. So no questions? Okay, there is one, actually. You wanted to go away, but it's
I tried to
not
escape.
yet.
I tried to escape to go to lunch.
Thank you.
Now, I suspect this might be just the subject for your next talk, but I'm curious because I'm a little obsessed with the Cyber Resilience Act, and I note that there are, I believe it's Article 15 of the CRA, there's interactions there as well with the AI Act and specific product requirements on AI, high-risk AI systems under the AI Act.
So the between what?
Between the AI Act and the Cyber Resiliency Act.
Yeah. This is something really interesting. The fact that one of the leaks that popped up yesterday are the fact that the EU realized that these interactions are not clear enough. So one of the core and I think the confirmed points of this new act that will come by the end of the year is clarifying the interplay between the two. And it's something already problematic on the market. So some of our clients already pose the same questions. At the moment, it is left by the industry to be regulated, but EU and the AI office realize that's a problem, and they are trying to solve it.